we decided to focus tonight's lecture on the Aarhus Convention. And I will show you how this framework is essential because first, Ukraine is partner to the Aarhus Convention. And second, also because civic environmental monitoring, which is at the center of all the project, all the GROMADA project, is actually often intersecting this legal framework, which offers a huge potential that is to date not duly acknowledged and duly mobilized by civil society actors to leverage the potential of civic monitoring for environmental justice. So, first of all, I would like to introduce to you the project from which I'm speaking. Sensing for Justice is a branch of the GROMADA project in the sense that Sensing for Justice was among the inspirations that, together with discussion with Web2Learn and other organizations, made it possible to shape the GROMADA project as it is right now. And the project Sensing for Justice was a research project hosted at the European Commission Joint Research Center from 2020 to 2023, and I was the principal investigator with a fund of the Dutch Research Council and the European Marie Curie program. The project intersects the Aarhus Convention because it wonders how we can leverage legal opportunities for civic monitoring. First, in court. So we wonder, how can this evidence be used in front of the judiciary? And if you're interested about this matter, please look at the GROMADA lecture that we co-host with the University of Copenhagen on using civic evidence to bring polluters to court. Second, which is key in this lecture, we posit that civic environmental monitoring can represent a new entitlement of civil society. This is the right of every person to contribute environmental information. And this is key because it doesn't just give the possibility of people to monitor, but actually the obligation of authorities to listen to the evidence stemming from civic monitoring. And lastly, civic monitoring can also trigger and facilitate processes of environmental conflict mediation. And we believe that this is key because we're talking about work contexts in the project GROMADA. And this is important to consider alternative spaces that are not just adversarial as courts, but encompass also, for example, spaces where we can mediate social and environmental conflicts. So let's start. First of all, when I started the Sensing for Justice project, I decided to combine two elements of my profile. I'm an environmental lawyer. I've been working in Ecuador, Chile, Japan, Texas, then lately Europe, on environmental crimes. But I'm also a researcher, and I believe that it's very interesting to see how ordinary people like everyone you can meet in the street, turn to civic environmental monitoring when they feel that an environmental issue is not duly addressed by the institutions that are competent to do so. They increase civic expertise and public knowledge, but they also would need institutional recognition to ensure that this act of monitoring can truly make a change. And this is why the GROMADA project is particularly interested in how civic monitoring practices can actually partner up with institutions, both academic institutions, but also, for example, policymakers, to ensure that this amount of evidence can really be used for a just and sustainable recovery. The project brought me to look at a number of legal texts to understand whether in the law out there we could find grounds to justify the contribution of ordinary people to indeed recognizing this sort of active citizenship and this contribution that all the people can bring to enforcing environmental law. So we selected a number of texts, legal texts, that would be particularly useful to legitimize civic contribution to environmental information. And we moved to the in-depth analysis of how these legal texts were mobilized in practice by civil society actors. And this is important because you will see that with conventions such as the Aarhus Convention, the very problem is that although the legal text is there, civil society actors often do not use the convention to its full potential because they may not know it enough. And this is why it's very important to have spaces like this of this afternoon, because we need to train civil society actors, but also be trained ourselves in how convention like the Aarhus Convention can be mobilized for the good. Or maybe they cannot rely on the Aarhus Convention because they don't have the resources, the legal capabilities to navigate this complex realm of the legal framework. So I would like to share with you some basic insights on this convention, but please do consider that the convention is really a useful tool. And if you're interested, please do engage with it further after this webinar. First, and I'm also happy to drop in the chat later on a few resources that could help you easily navigate in this legal text. So the Aarhus Convention has been initiated by United Nations Economic Commission for Europe. So it encompasses all European Union's countries, because the European Union is party to the Aarhus Convention, but it doesn't limit itself to the European Union. And this is crucial for Ukraine, because Ukraine is indeed party to the Aarhus Convention, albeit it doesn't yet is part of the European Union. The Aarhus Convention has more than 20 years because it came into effect since 2001, and it was deeply imbued with all the discussion that surrounded the Rio Declaration back then in the 90s. The idea back then was to make environmental information more horizontal, more democratic, and recognize that for sustainable development, everyone is both a consumer and a producer of environmental information. And the active participation of civil society in ensuring a truly representative and transparent and rich environmental information is key to ensure that the sustainable development challenges are met. What does the Aarhus Convention do, in short? First, it grants civil society, citizen, and environmental organization procedural environmental rights. Here, for those of you who are not lawyers, it's important to distinguish between substantial and procedural environmental rights. One reinforces the others because substantial environmental rights are key to ensure that, for example, the right to a healthy environment is recognized and supported. But without the procedural environmental rights, which are subordinate but functional to the substantial rights, we wouldn't be able, for example, to check what the government is doing to ensure that the right to a healthy environment is duly implemented. Indeed, with procedural environmental rights recognized by the Aarhus Convention, we can enjoy three main set of rights, which are also called the Aarhus Convention 3 pillars. First of all, we have the right to access environmental information that is held by institutions, Articles 4 and 5, which means that institutions must facilitate with all means available this access through, for example, open databases and a swift handling of requests to institutions by civil society. Second, which is the second pillar, is the idea to boost public participation in decision-making that may have an impact on the environment. And this means, for example, opening up the black box of decisions on, for example, a new urban plan to a meaningful participation, which doesn't mean just being consulted, but rather means acknowledge the contribution of people and listen to it and explain how this contribution has been considered in the final decision. Lastly, we are not left with no means if the first two sets of rights are denied. Indeed, we can access courts whenever these two rights have been denied if we are citizens, and all the time challenging these decisions if we represent civil society organizations whose interest is de facto, even if we don't have an evidence of any personal interest, we can still, as a, for example, environmental organization, access justice because we represent indeed cross-cutting and transversal interests of all civil society. Now, of course, the second set of rights, the second pillar, is the most useful for us today, but also the first and last, because indeed they complement and give the context of what I will call the right to contribute environmental information. As I was saying, Ukraine is party to the Aarhus Convention. However, it's not just enough to be party, because indeed, we need governments and institutions willing to implement this convention. And sadly, there have been several decisions of the Aarhus Convention members of the party calling for compliance with the Aarhus Convention by institutions in Ukraine because data showed a growing incompliance with the text of this convention. So the government came up with an action plan in 2008. The action plan is currently being monitored in its implementation. And I would welcome also people from Ukraine sharing with us their experience in, for example, accessing environmental information by the government and how they witnessed improvements or step backwards in actually the implementation of this key convention. Here is key if you are interested, for example, to check your own country compliance with the Aarhus Convention, to check indeed the Aarhus Clearinghouse for Environmental Democracy, which is kind of a watchdog by the Aarhus Convention that ensures that this convention doesn't stay just a letter, but it becomes something more than only words. Now, how we could come up with a new right? This seems challenging, but at the same time, I've been talking about this right in conferences, public fora, civil society meetings, looking at interviews. And actually, this right is often embedded in the practice of many citizen science initiatives, but also of many policymakers that actually recognize the value of ensuring that civil society can contribute to environmental information. I give you an example. The rapporteur on toxic and human rights of the United Nations, Mr. Orellana, recognized that this right is actually a timely right to be infrastructured exactly because it's no longer possible to consider the people just passive recipients of information, but rather as co-contributor together with the same institution that are producing this information. So, as some of us are indeed, let's say, familiar with legal text, I would like to guide you through what the convention says and why I believe we can, let's say, implicitly read a right to contribute. It's true that Articles 4.1 and 4.2 says that the right to access environmental information is only, let's say, only encompasses information held by public authorities. So this would say then the citizens are not public authorities, so this information is not part of the obligation. However, institutions have to make all efforts needed to gather accurate and detailed environmental information and actively disseminate this information to ensure a greater opening up of this information to the public. So there are many instances where this information is not held by public authorities because, for example, they don't have the resources to monitor with the granularity that would be needed. For example, in a war-affected zone where biodiversity losses are not being tracked because clearly the institutions have other priorities. Or in other cases, institutions are not even aware of a problem or they don't want to monitor. And I give you the example of oil extraction sites in South America and also in Latin America, for example, but also in south of Italy, where institutions intentionally covered and didn't disclose environmental data. So in these circumstances, one can say that authorities may have the duty to consider and disseminate civic gathered information when this helps to fill informational gaps and to better inform the public. Because if a civil society organization gathered some data that is of interest, can be of interest for a greater number of people, then we can say that there is an obligation to actively share this information also with broader society. So let me also take another article, that is the Access to Justice article, which doesn't only talk about sharing information, but actually sharing information in an adequate way, which basically means that in order to ensure that we have an adequate level of information to the public, actually we could consider civic evidence as complementing the official information that is held by authorities. So if institutions need to take all measures to inform the public properly, then they may have to consider citizen-gathered data and even support their production when this is functional to fill informational gaps. So read together these rights make us assume, let's say, posit that we can actually interpret the Aarhus Convention in an expansive way. And what is even more interesting is that the Escazú agreement that I will tell you about shortly enshrines a principle, which is the pro persona principle. That is, we have to interpret the convention to the greater benefit of civil society when this is not explicit in the letter of the law. So it means, in doubt, pro persona, in doubt, we need to favor civil society. And in this case, I think this doubt should be resolved in a way that is more open, more supportive, the right to contribute. And in the last years, I was pretty happy to see other scholars, civil society organizations, NGOs, think tanks, referring to the articles that I wrote on this matter, asking for reinforcing these statements with other arguments. And actually, it became a movement. So more and more, the right is more credible. And this is why also we need more people to familiarize with it and to start applying it in their practice. Lastly, I wanted to mention the key protocol on pollutant release and transfer registers. So all UN member states, even if they're not parties to the Aarhus Convention, can join this register, which is basically a register of all the pollutant release that have been basically caused by corporations, but it's the duty of the state to ensure that corporations have complied with the registration duties on what pollutants they are releasing in the environment. So the objective of this pollutant release and transfer register, which is a very difficult name, is to enhance public access to information through the establishment of coherent nationwide pollutant release and transfer register. And over time, there have been several occasions of civil society organizations appealing to this protocol in order to have disclosed information. So some time ago, I approached the protocol secretary and I asked to them, given that at Article 4, they allow for public participation in the development and modification of this register, I asked them to what extent and based on which criteria this participation by civil society has took place so far. And what are the standards, if any, to ensure that civic evidence can be considered admissible to contribute and update these registers. The secretary answered to me that they have the space for this type of contributions. They would be up to apply even adapted standards compared to those that they ask to corporations and governments, but that so far they haven't been basically asked with contribution by civil society. So they would be open in principle. It's just that they haven't been presented with this type of evidence. So this maybe gives an hint to the civil society organizations out there to consider this protocol as a potentially useful tool to leverage further the contribution of civil society actors. Now, I mentioned before the Escazú Agreement. Interestingly, the agreement Escazú, let's say, we call it in short Escazú Agreement, which entered into force since 2021, has been basically the young brother of the Aarhus Convention, or young sister, because it came into effect 20 years later. Let's say, in the making of this Escazú Agreement, the Economic Commission for Latin America and the Caribbean made an interesting choice, that is to be very lengthy in the wording, which is something that I noticed already in Latin America constitutions when I was working on it, for example, for my master thesis back then. And I noticed that sometimes adding all these words do not necessarily help for the actual enforcement, because basically the wordiness creates confusion. At the same time, many observers noticed that this Escazú Agreement, being really the brother of the Aarhus Convention, offers interesting insights on how we could interpret both conventions, so both the Escazú Agreement and the Aarhus Convention. And in particular, I would like to cite here Article 7.4, that due consideration can be given to the observation of the public contributing to the process. So this element of due consideration is, let's say, put even more explicitly. And interestingly, each party has to say upfront how this observation have been taken into consideration. Again, an interesting passage, which I think is key for citizen science, is that each party shall promote regard for local knowledge, dialogue, an interaction of different views and knowledge where appropriate. This is very important because I often say that it's not just about environmental justice, but also about epistemic justice, which is essentially the inclusion of different knowledge systems to inform the evidence on which decisions are taken. So, interestingly, the Escazú Agreement basically encompasses all the history of Latin America of integrating or non-integrating, because in many cases this was actually not done properly, the amount of knowledge that was produced and shared by local leaders, by communities, by indigenous peoples, and also the Escazú Agreement know where this convention has to apply in Latin America, where several barriers to participation exist. And so this is why they also, in the convention, the parties want to ask states to actively eliminate those barriers that prevent participation. Lastly, and I would like to stress this, especially as we are talking about a war context. In a war context, it can happen that civil society leaders are criminalized just for doing their job. It's very important to ensure that each environmental activist, environmental informant can use their evidence in a safe way, can share it. And so it is why Article 9 at point 1 says that each party shall guarantee the rights of environmental defenders and ensure that they are free from threat, restriction, and insecurity. So the Aarhus Convention inspired the Escazú Agreement, but the Escazú Agreement contains provisions that are not currently present in the Aarhus Convention, probably because we feel way less pressure in Europe to defend environmental leaders. But we've seen, unfortunately, how many journalists, how many activists have been themselves exposed to legal risks and at times even personal risks just for doing their job of warning society on environmental matters. Interestingly, this Escazú Agreement pushed leaders in Europe to consider more the risk of environmental defenders. And I can mention, for example, a new directive which is countering SLAPs, the strategic lawsuit against public participation, which are strategic litigation targeting exactly defenders, activists, journalists, and trying to silence them through threatening strategic litigation or starting very costly litigation. So also in Europe, we are being worried about the risk for environmental leaders and maybe learning from this Escazú Agreement. So at this point, I would like to invite Gabriel, who has also been collaborating with Systasis, one of the GROMADA partners, and also as he's himself researching this topic and has been working as an environmental lawyer in Latin America. So I believe some insights on the barriers and also opportunities offered by this Escazú Agreement could be interestingly shared by him. So Gabriel, over to you.
Thank you very much, Anna. My pleasure to be in front of all of you, and thank you very much for participating. I would like to just briefly address the Escazú Agreement is inspired by the Principle 10 of the Rio Declaration to guarantee access to information, participating in decision-making, and environmental justice, as Anna already explained very well. So its current status, it is signed by 24 countries out of 33, and just 16 are member states. Which are the impacts of the Escazú Agreement? It constitutes an instrument that aims to put environmental democracy into practice. And the most important thing, in my opinion, that it's doing right now is that it includes new principles to the international environmental settings in Latin America and the Caribbean. such as, for example, the principle of progressivity or non-regression, which is established in the Article 3, letter C, and implies never going backward in an improved environmental situation. But what does the principle of non-regression and progressivity mean? Non-regression means that in the recognition, protection, and implementation of the rights achieved, and progressivity implies the duty to progressively advance in the protection of environmental rights without regressing to norms that are less protective than those in force. This principle, I would say, is fundamental to the Systasis Agreement because it ensures that the states do not go backwards in the progress made in protecting the environment and implementing the provisions of the agreement, or eventually in recognizing citizen-generated data. One of the applications that we could see in these matters, I just want to also address and stress that it's very new, and in the last COP in 2023 was held in Chile, and we're just starting to making the action plans for establishing new rights and for implementing the Article 9 about protection to environmental defenders. But why then is it important to become a member state? And here I would like to quote a case from Claude Reyes and others versus Chile in front of the Inter-American Court of Human Rights with respect to provision of access to public information. This case was won by the plaintiffs and triggered compliance and creation of new law on access to public information in Chile. What does that mean? The jurisprudence became a starting point and a catalyst for development of access to public information and transparency throughout the continent. After the implementation and compliance by the state of Chile, many states across Latin America and the Caribbean implementing rulings of this type, boosting, therefore, access to public information in the region as a fundamental right. Just as an example, just 3 Latin American countries had clear normatives about access to public information before the sentence in 2006. And now, just 3 countries does not have a clear access to public information. What does it mean? That the Systasis Agreement can also serve as a tool to push governments and states to actually issue and improve information, and in this case, maybe contribution of citizen-generated data. One of the difficulties, exactly as Anna said, is the wording. The ratification is slow and complex, and the main reasons for not ratifying the agreement has been sovereignty reasons, and some countries also are that they already have in their existing laws the same laws or mandaments of the Systasis Agreement, although their uptake is very limited since these norms are frequently below legal level, so they are actually insufficient to develop a normative level.
Thank you, Gabriel. I really appreciate it also because you pointed to a principle that I was also that I forgot about, which is really important, and I actually learned from you about this, which is indeed this idea of like non-regression. And as we are close to the European Parliament elections, we fear a lot of regression, for example, in the Green Deal. And this is why it's actually important to ensure that the achievements that civil society have conquered through struggles are not lost in the process of, for example, renegotiating political leadership. So thank you again. I'm now going to indeed question we saw that the right to contribute is potentially very useful, but what do we need to ensure that this right can be practiced? So first of all, if a right like this would be recognized as a fourth right under the Aarhus Convention and potentially under the Systasis Agreement, we would need both legal adaptations and governance adaptations, because institutions should be able to handle this right and understand, for example, which resources are needed in terms of, for example, portals where civic monitoring actors can contribute structurally information to the authorities. Then there's also the question, would this just be possible for institutions to use unofficial data, or rather mandatory under certain conditions, when, for example, official data is insufficient? And also, which other frameworks can reinforce these conventions, such as, for example, the Sustainable Development Goals, or the European, let's say, legal framework on improving public services? So how can we ensure to build an infrastructure that can facilitate a right to contribute? And in this, with the European Citizen Science Association, back then, some time ago, we started this dialogue, which continued up to today, where we are actually fine-tuning the Aarhus Convention text, and especially the electronic information tools recommendation, which is an add-on kind of explanatory document to the Aarhus Convention, where actually we managed to have recognized citizen science and open science as instruments that can kind of reflect the progress in electronic information tools, because these tools and this recommendation have been drafted decades ago, when it was not even conceivable to have the citizen producer of environmental information. So we need to open up the Aarhus Convention and accept that it can evolve. And maybe the Escaso Agreement, as it is more recent, may even evolve faster, because it's more kind of shapeable, can be shaped a bit more. Then I would like to invite all of you that are interested in practicing this new right to access this article that we published just last year on the journal Citizen Science Theory and Practice, on a special issue on citizen science and the law. Here you would find useful scenarios to understand how we can better infrastructure this new right. At the same time, when we recognize a new right, we also have concern. For example, would this risk to hamper innovation from the grassroots? Because basically we are imposing rules and regulation on a practice as civic monitoring that is inherently very changing and very versatile. At the same time, without a right, we can still have these issues with legal conviction of activists, with pressure by the police, intimidation. At the same time, the right can be a burden for institutions having to change their laws to kind of implement this right. So it's not an easy solution. We are also gathering the pros and cons, and like discussion like the one of this afternoon are exactly needed for this. Now here, I would like to take a point that I already addressed in the webinar with the University of Copenhagen, that is the fact that in work contexts, the issue of criminalization of environmental defenders become even more evident. This is why legal professionals, but also academia, researchers, have to support these activists in gathering this evidence and contributing in a way that is safe, and also in a way that is impactful, because these people risk sometimes their life. Think to the activist Berta Cáceres, killed because she was really striving to defend the environment for all of us, not just for her or her community. And this can occur and is occurring in many countries, also in Europe. So the recognition of a new right can actually contribute not only to more open society, but actually also to the safety of these people. And here I would like to just ask Gabriel, because we had this conversation some time ago on the risk that citizen science pose in contexts such as those of Latin America. So I would like to ask you, which types of risk have you experienced or witnessed as a lawyer working in a context like Latin America, in a context like resources extraction or, for example, forest exploitation, that can be very risky for environmental defenders.
Yeah, thank you actually for the question. I would say, well, globally, the oil, gas, and mining industries are the biggest drivers of this issue, which is not only about criminalization, but also, as you said, about like killing environmental defenders. We have to say that the Escazú Agreement is the first environmental treaty addressing this topic and the first in the world to contain specific provisions on the protection of human rights defenders. Just as a brief data, from 2022, state, for example, in Colombia, just 322 people have been killed over the last 10 years while defending their lands. And only in 2019, 64 activists got killed in Colombia for the same reason. And as a contrast, in 2019 as well, in Europe, just 2 were killed related to illegal logging activities in Romania. So definitely it's an issue that we have more in South America than in other regions, at least in comparison with Europe. But we have to be clear that the entry into force does not guarantee that the killings of environmental defenders and leaders will stop. We need definitely more important tools and more like restrictive tools in terms of security and using the public forces, because it doesn't matter if you have like a great law that protects everyone if you don't actually have a way to implement and this time and use public funds to actually protect those people who are under risk. So, and why I am addressing this? Because the 3 main actors of criminalization, now jumping from killing environmental defenders to criminalization, are the state, companies, and public forces, through mostly 4 mechanisms. First, they promote and approve promote and approve environmental control regulations that benefit the extractive companies operating in the territories. Second, they approve lax regulations in favor of indigenous people that in practice actually do not guarantee effective protection of their rights. Third, they issue regulations that allow the security forces to protect the economic interests of private sectors. And fourth, they stigmatize and discredit public and legal complaints about environmental damage in indigenous, mostly, territories. So, yeah, the report, for example, of the Inter-American Commission in 2018, together with Global Witness, noted that companies usually use this punitive power of the state, using legislature judges with corruption sometimes, to stigmatize and delegitimize environmental defenders. Cases are numerous. In Mexico, people has been in the Colonia Maya, Zacatepec, Chilón, and Civilpech cases. They definitely use disproportionate use of the criminal justice system against protesters, which is part of a broader strategy of disincentivizing and dismantling advocacy for land, territorial, and environmental rights. In Peru, the same case, mostly people defending the lands, the territories, zones that are protected under legal protection for conservation. They have been criminalized just for exercising the right of protest and protecting the environment. Not going that far, in Chile, we have some cases where people was prosecuted for the crime of terrorist arson for allegedly participating in an arson attack, despite there being no hard evidence against a woman called Macarena Valdez in a national park called Los Ruines. Same case, or same setting in the scenario of the caso Catrillanca, who was a Mapuche member of the community protecting the lands of the Mapuche people and the natural resources. He got shot by the police in a really not clear case until now, but justice, just by defending the territory. But he was constantly looked for the police. Every time he was doing something, they were coming to him without leaving him actually live in peace. So in general, as a conclusion, there is a pattern of misuse of criminal law, disproportionate application of force, and arbitrary arrest and judicialization of environmental social protest through criminal offices such as public disorder, threats, or even anti-terrorist laws. Of course, with the aim of criminalizing and delegitimizing whoever defends the environment in such cases.
Thank you, Gabriel. I think what concerns me most is actually the fact that at times it's the state that is criminalizing, as companies do. And this means that sometimes a recognition of a right by the state itself who wishes to silence the process can be a big institutional greenwashing or social washing. And this is why actually in the article that I cited on citizen science theory and practice, we propose not to have the right in all cases, but really to have the right as a benchmark that can be strategically used by actors in court, for example, but that the right is just a tiny, tiny element of a bigger change that has to come and that mobilize really all the professionals, the researchers, so on and so forth. And this is why I think projects like GROMADA are very useful, because they foster these types of partnership that will strengthen the capacity of civil society, for example, in Ukraine, when they will turn to courts with the evidence that they have gathered. So again, this is an invitation for all the professionals listening to ensure that the responsibility that you have to defend environmental defenders and to give them a voice, a chamber of resonance, please do so, because it's so essential. Now, we are really and I would like also to keep a few moments for questions. We are a bit beyond time. We will ensure to wrap up now. So civic monitoring, as I posit, is a form of rights in action, the right to live in a healthy environment, but also procedural rights, such as the right to access environmental information, and eventually a fourth right under the Aarhus Convention. We believe that there are also other rights at stake, for example, the right to science, recognized recently by the UN, and freedom of information rights, which instead have a long history of application. Now, as we're closing, I would like to ensure that you can keep an eye on the next GROMADA events, because these topics will come up again and strongly. So first, next Thursday, June 6th, we have an expert legal workshop exactly working on the legal challenges that community performing environmental citizen science in Ukraine are facing. And we will hands-on select challenges, identify strategy for action, listening from the needs of the people that are really on the ground working with this data and aiming to bring this data to one day a court. Second, we would like to invite you to the next webinar of this series. That time will be hosted by Odessa State University on impact of armed conflicts on water resources and infrastructure, a case study of Ukraine's water infrastructure. And I know this is a very pivotal topic, so please do register. And lastly, on June 14th, so the day after, very busy week for GROMADA, we will have a follow-up workshop to the European Citizen Science Association conference that we joined earlier in April, where we organized a workshop on civic engagement in environmental recovery in Ukraine through higher education institution cooperation with communities. And we organized a very informal, agile follow-up workshop and together with the partner sister project City Ops. We hope you can also join this event. You will find all this information in the news on the GROMADA website. I would like to thank you for your attention, and please do follow us on social media, on YouTube. If you have questions specifically on this presentation, do reach me. If these questions are also for Gabriel, I will engage Gabriel as well in the reply. So thank you again for your attention, and I believe we can